One juror was questioned today by Chief Justice Toll regarding the alleged jury tampering allegations in Alex Murdaugh's bid for a new trial. So we know that on Monday, this coming up Monday, January 29th, is when all of the jury is going to be asked a discrete number of questions by the judge, and then also Becky Hill. But today, on Friday, January 26th, one juror got special treatment, special accommodations, because this juror already had a prepaid vacation, and therefore the judge allowed for this one juror to be brought in and questioned today on Friday, January 26th, and the rest of the jury is going to be questioned on January 29th on Monday. And the judge said in court, apparently, that no one is allowed, anyone who's there from the press is not allowed to talk about any of the proceedings, and not allowed to say what questions were asked of that jury. But we have something which is a little bit of an inside scoop, because there was something filed. It's a public record, so assuming we can talk about it, it's a public record, and it was filed by the Murdaugh defense team, and it was in response to the judge actually requesting input from the attorneys about her proposed questions. So we see at least what her proposed questions are, and we see some of the Alex Murdaugh's responses or objections to some of those questions. And we do not see the state's response. Apparently the state did not file it the same way that the Murdaugh team filed it. But we do see some of the judge's proposed questions, at least according to the Murdaugh team, which we would think is accurate because they're responding to specifically the judge asking them for input on her proposed questions. So let's jump into that right now. So it's a letter. It's actually written in a letter form on Harpetunian stationery. And here we go. Dear Chief Justice Toll, I write in response to the email from Mrs. Diaz dated January 24th, 2024. So Ms. Diaz, apparently, who seems to work for Chief Justice Toll, maybe she's the clerk, sent them an email on January 24th, 2024, just a few days ago, communicating your desire, meaning the Chief Justice Toll's desire, for responses from counsel to the court's proposed questions for the jurors and for suggested questions and topics for the examination for Rebecca Hill. I've attached Mr. Murdaugh's proposed juror questions as Exhibit A to this letter. So Exhibit A is also attached with the Murdaugh's team's suggestions of questions that should be asked to the jurors. So let's go through each question, each proposed question that the court has, and see what the Harpetunian response is. Mr. Murdaugh objects to the court's first proposed question. So here is the court's, Justice Toll's, first proposed question. Now again, we don't know if these are the actual questions that were eventually asked. It could have been there was more argument on the day of today during the hearing, and we don't know what the language of the actual question is, but this was her proposed question. Number one, the verdict of guilty you rendered on March 2nd, 2023, is that currently your verdict in this case? This is the question that she first wants to ask the jury. So let's see what they respond to this. Why is there an objection? The issue under the legal standard adopted by the court is whether Ms. Hill made comments during trial that affected the vote of any juror on March 2nd, 2023. Right? That is what Judge Toll, or that's what she found. She found that they have to actually prove bias. They have to prove prejudice. It's not presumed. And we spoke about this in my last video. If you haven't seen that, you have to check it out, because in my opinion, she's using State versus Green, and it seems to me that she misunderstood her and is misapplying State versus Green's holding, and therefore she's requiring the Murdaugh team to actually prove prejudice when really the prejudice is actually presumed. Okay, but that's for the last video. Go check that out if you haven't seen that yet. So they continue. Mr. Murdaugh objected to that standard, which I explained in my last video, but even under it, what a juror would or would not do a year after the trial has no possible relevance to any issue before the court. Who cares what their verdict is today? It's all about what their verdict was and how they came to the verdict in March 2nd, 2023. Now, I will point out that this is not just the Alex Murdaugh's team who's taking that position. Actually, if you look in the response, the state's response to the Alex Murdaugh's team's motion for a new trial in the first place, their response in a footnote when they're quoting State versus Green, and the first question in State versus Green that the judge asked the jury was, and remember, in that case, there was the bailiff told the jurors that there might be an Allen instruction if they're deadlocked. That was the extent of their conversation. And this is what the judge questioned them. The first question was your verdict guilty on both charges, and is that still your verdict? So that is the first question that was asked in State versus Green. Now, there's a footnote. The state over here, the state in this case, quotes this case, quotes these questions, and then they have a footnote here. And if you look at the footnote, it says the following. In the present case, we are now many months, documentaries, and juror interviews removed from the verdict, and so the question of is that still your verdict is not one of probative value. So here you have the state essentially agreeing to the Murdaugh team that this question is really not relevant. Now, I do not know if the state changed its position since they filed that response. I don't know if today they're saying you should be allowed to ask that question. But if I was the Murdaugh team, I would have that footnote ready to say, look, the state even agrees with me. And when you have both attorneys agreeing that a certain question shouldn't be asked, that's more likely that the judge will go along with the attorney's suggestions. But I don't know if they did that. I wasn't there. So, but again, we have both sides apparently saying that that question is really inappropriate. Now let's move on. Judge Hocker did pose a similar question to the jurors in Green. The judge in State versus Green was Judge Hocker. And remember, this is the case that Judge Toll is saying she is following. Judge Hocker did pose a similar question to the jurors in Green, but he did so when polling the jurors immediately after the verdict and before they were discharged. So here, they're saying you have to be able to distinguish State versus Green and our situation here, because in State versus Green, the judge did ask that question. The judge asked, is that still your verdict? Now, it happens to be that that specific question was not taken up on appeal, whether the judge should have asked that question or not. So there's no real binding authority about whether that question is appropriate or not. But nevertheless, that is a question that was asked, and therefore the Murdaugh team is distinguishing between what happened in State versus Green and the situation that we have in the Murdaugh case. And it's a very valid distinguishing character, because in State versus Green, the jury didn't go out, they didn't do interviews, they didn't see any documentaries, they didn't do anything. They're still practically in the courtroom, in the courthouse. They just finished the deliberations, and now they're just being asked these questions. So that is much more of a fair question in the State versus Green case than it is in this case. Here, a year has passed since the start of Mr. Murdaugh's trial. Asking jurors how they feel about the verdict today is both irrelevant and prejudicial, in that it invites jurors to consider a full year of post-trial media coverage when answering questions about events during trial. I have to say that they're making a good point. Further, if a juror did answer no, that it's not their verdict, the court would be compelled to ask why, which could have only two possible answers. Some irrelevant consideration arising after the verdict. So it could be that they changed their mind because they saw some documentaries or other things, or reflection on some perceived defect in jury deliberations, or because they realized that some of the deliberations maybe didn't go the way that they thought it should, and they were rethinking everything, and that's why they changed their opinion now, as to which jurors cannot testify under Rule 606B of the South Carolina Rules of Evidence. So we're going to get into Rule 606B in a minute. But 606B essentially just says that what happened in the deliberation room is irrelevant. We can't discuss it. It shouldn't be brought up. And the jury cannot change their minds now after the deliberations happen. So it's a closed book. Anything that happened during deliberations should be a closed book. That's really what 606B says. So let's move on now. So that's with respect to their court's first proposed question. Let's move on to the second proposed question. Mr. Murdaugh objects to the court's second proposed question. What's the second proposed question? Was and is your verdict based entirely on the testimony, evidence, and law presented to you in this case? So here we go. This question violates Rule 606B, which we just discussed briefly, which provides in part, and now they're just quoting 606B. So this is what it says. Upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to, and then there's a ... so there's some parts that they're skipping out here, the effect of anything upon that or any other juror's mind or emotions as influencing the juror to assent to or dissent from the verdict or indictment, or concerning the juror's mental processes in connection therewith. So we cannot probe into their mental processes. We can't probe into the deliberations. This question violates the rule because it directly asks the juror what did or did not have an effect upon that juror's mind or emotions as influencing the juror to assent to or dissent from the verdict. Mr. Murdoch understands the court has decided to directly ask jurors about what affected their verdict because it has held prejudice must be proven by evidence on that point rather than presumed based on the source and content of the illicit communications per federal authorities. So they're saying, well, we're kind of in a catch-22 here, because really what they're saying is that the court, since the court already has ruled that they have to prove that this prejudiced the verdict, so then that automatically means that you're going to be asking them, did this go into your deliberations? And did this affect your verdict? So how does that not contradict 606B, which says you're not allowed to ask questions about the what affected the verdict? So they just throw in a line here that, oh, by the way, this is against the federal authorities such as Remmer versus United States, which says that prejudice is presumed, which means you don't need to ask questions about what went into their deliberations and what affected their verdict. And they quote here Parker versus Gladden and state authorities. And then they also say some state authorities like State versus Cameron. Now we spoke about State versus Cameron, and I still can't understand why they're arguing State versus Cameron, which I told you is almost certainly decided wrong in my opinion. They should have just said, and in State versus Green, which adopted Remmer. But they didn't do that. And so he asserts this objection for preservation purposes. So really they're saying that according to the judge's ruling that you have to prove prejudice, then this question is technically okay. They're just objecting to because they object to the whole standard in the first place, so they're also going to obviously object to this question being asked. Now, here's an interesting point. Additionally, Mr. Murdoch objects that the second proposed question is highly suggestive of an affirmative answer. So when you ask a question, this is the problem with sometimes leading questions. Leading questions suggest an answer. And when you're calling a witness, and if it's not an adverse witness, then you're only allowed to ask open-ended questions. You're not allowed to lead them to the answer. So what the Murdoch team is claiming is that when you ask them, was and is your verdict based entirely on the testimony, evidence, and law presented to you in this case, you're suggesting, excuse me, that they should answer yes. It could, and likely would, cause a juror to reasonably believe the court prefers he or she give an affirmative answer. So this is their argument here. Now this argument I don't hear as strongly, just because you want to look good, that's a different issue than the way that you're formatting the question. The format of the question is, I think, pretty fair. Was and is your verdict based entirely on the testimony, evidence, and law presented to you in this case? It's either a yes or no. So you could say, it was, or you could say it wasn't. You're not suggesting really an answer. You're not suggesting yes or no. So this is not, I would say that this is not the strongest argument that they have to make, the second objection. Continuing, Mr. Murdoch objects to the court's third proposed question. What's the third proposed question? Was your verdict influenced in any way with any communications by the clerk of court, Becky Hill, in this case? So that's the third proposed question. Was your verdict influenced by any communications? Now, the only reason why you would get to this question is if they answered, was and is your verdict based entirely on the testimony, evidence, and law presented to you in this case? And then if their answer would be no, then you get on to the next question. So I'm assuming that this question is only if they answered no to question number 2. And then the question was, well, okay, if it wasn't based entirely on the testimony, evidence, and law presented to you in this case, well then was it based on communications with the clerk of court, Becky Hill, in this case? And then they say the following. They argue the same objection, essentially what they just argued. This question directly violates Rule 606B for the same reason the court's second proposed question violates that rule. Now, they say another question. They have another point here. Mr. Murdoch additionally objects that the language, your verdict, is unclear. What do you mean, was your verdict? It could be taken to mean the juror's own vote. What does it mean, your verdict? Does your verdict mean my vote? Or does your verdict mean the collective verdict of the jury? Or it could be understood more literally to mean the collective decision of the jury of which the juror was a member. So therefore, it's an unclear question. Mr. Murdoch also objects to asking this question before asking the juror whether he or she heard any comments on the merits by Mrs. Hill. So you can't ask this question before you ask the question of, well, was Ms. Hill's communications with you regarding the merits of the case? If a juror heard no comments by Ms. Hill, there's no reason to ask what effect Ms. Hill's comments had on the juror's verdict. Reserving his Rule 606B objection, Mr. Murdaugh therefore proposes this question be asked after the juror is asked if Ms. Hill made any inappropriate comments, and that it be rephrased to as, did Ms. Hill's comments prejudice you against the defendant Alex Murdaugh in any way? So they want the third question to be like what we just read. Did Ms. Hill's comments prejudice you against the defendant Alex Murdaugh in any way? Now, I want to point out one other thing, and that is that in the State versus Green case, so the State versus Green case, we have this Judge Hocker that asked a number of different questions. And I'm going to read some of the questions. So we read the first question, which was your verdict guilty on both charges, and is that still your verdict, which we discussed already, whether that question is appropriate in this case. And then his next question was your verdict based 100% on the testimony, evidence, and law presented at this trial, which was essentially the same exact second proposed question by Justice Toll, I'm sorry. And then, was your verdict influenced in any manner by any communication with any of the bailiffs or any other person outside of the 12-member jury? So was it influenced by anybody out of the jury? And this is essentially the third proposed question by the court. So the Justice Toll is basically just copying and pasting the questions that Justice Hocker asked in the State versus Green. Now, with respect to these specific questions, what did the Court of Appeals have to say about these questions? So, as I said earlier, they didn't really bring up this issue. They didn't take up this issue. But, actually, in a footnote, they say something interesting. And this is why you also have to read the footnotes. When you're doing some research, legal research, and reading these cases, you also got to read the footnotes. And this is in the State versus Green appellate decision. So remember, there was two different opinions. There was an opinion in the Court of Appeals, and then that was appealed up to the Supreme Court of South Carolina, and then the Supreme Court of South Carolina authored an opinion, Justice Kittredge, and that was the opinion that adopts, in my reading of it, adopts Remmer versus United States as the correct standard. But in the Court of Appeals, this is what the footnote says. Not before us, this is footnote number 3, not before us is the issue of how far a trial court can go in questioning jurors post-verdict without crossing the bounds of Rule 606B. So this exact issue that the Murdaugh team is bringing up about how do we not contradict Rule 606B with some of these questions that you're asking about the deliberations, about whether it affected their verdict, the Court of Appeals is specifically saying we did not take up this issue. We're not taking up this issue. It wasn't preserved, or wasn't a basis for an appeal. It wasn't one of the reasons that they appealed. And this is what they say. Some courts have ruled such questioning may only explore the existence and nature of the outside contact and may not delve into its effect on the jury. So, pause for a second. Why are they saying that extra statement? Why don't they just say, why does the Court of Appeals, the South Carolina Court of Appeals, say, it's not before us. It's not an issue before us, and therefore we're not going to talk about it. And then just say that, all issues that you want to appeal have to be brought up and have to be preserved, and they have to be brought in front of us, and then we can make a decision on it. And since you didn't do that, we're not going to even discuss it. But they don't do that. They say an extra line. And what they say is that some courts have ruled such questioning may only explore the existence and nature of the outside contact and may not delve into its effect on the jury, which suggests that the Court of Appeals is agreeing with that. Why would they say it otherwise? Just say nothing. Say it's a question. But the fact that they're bringing that up almost suggests that they approve of it. Now, of course, this is dicta, and this is an argument that an attorney could make. It's not binding, and sure you can argue that they're saying, well, only some courts, but other courts have held that. But they didn't say that. They didn't say some courts held this way and some courts held the other way. They just quoted the courts that held that you should not be asking questions, that you should not delve into the effect of the outside contact and delve into the effect of that outside contact on the jury. So this would suggest to me almost, and certainly an argument that the Murdaugh team should have made, that here you see clearly, not clearly, but here you see at least some dicta in a footnote. And of course, like I said, I know it's not binding and it's not the body of the opinion and all that good stuff, but certainly it's something that would seem that the Court of Appeals is agreeing with that rationale. And that's something that you can argue that therefore we should follow more strictly Rule 606B and not ask questions into what affected their actual verdict and just ask questions about the actual communication and how prejudicial the communication on its face looks like. Okay, let's move on. Mr. Murdaugh objects to the court's fourth proposed question. So now we have the court's fourth proposed question. Did you have any communication with Becky Hill about your verdict in this case? So that was the next proposed question. And the follow-up, if yes, what did Ms. Hill say? So they have an objection with this as well. Because, what's their objection? Have any communication with Becky Hill is an unclear statement. Mr. Murdaugh suggests a more clear and direct question. Did you hear Ms. Hill make any comments about the testimony, evidence, or arguments presented by the state or defense during Mr. Murdaugh's trial? Why would you, essentially they're saying, why would you ask a question, did you have any communication with Ms. Hill about your verdict in this case? And then if you did, what did she say to you? Instead of saying that, just say, what comments, did you hear any comments about the testimony and evidence and arguments? And that's much more specific. It's not just about a general, about your verdict. It's much more specific about what the question, what the communications involved. If the answer is yes, in addition to asking what was said, Mr. Murdaugh believes the court should ask when it was said, where it was said, and who else was present when it was said. And as explained above, Mr. Murdaugh believes what, if anything was heard, should be asked before the court asks what effect it had. Okay. Now, Mr. Murdaugh again objects to including counsel for jurors participating in the merits of this proceeding for the reasons previously briefed. So apparently, it seems that Eric Bland is somehow getting involved, and the Murdaugh team doesn't want Eric Bland involved at all. And this is what they're arguing. He respectfully submits the court should not have included, meaning Mr. Murdaugh submits, meaning this is the argument, that the court should not have included Eric Bland in correspondence discussing what questions we posed to his client. So the court actually apparently included Eric Bland on this correspondence about what questions should be potentially asked to the jurors which he is representing. So they're arguing that he should not be included in what, he should not be involved in the room. He should not be in the discussion about what questions should be asked. And this is what his argument is. I am aware of no precedent for a court providing a witness's lawyer with an advanced copy of the questions the witness will be asked during a criminal proceeding. Fortunately, there was no prejudice to Mr. Murdaugh because the court granted Mr. Murdaugh's request to sequester the witnesses, and Mr. Bland agreed to abide by the court's decision. So they're saying, okay, no harm, no foul, but let's just understand that Eric Bland should have nothing to do with this, and let's keep him completely out of this. Okay, then they say that that we have to make sure that these proceedings stay quiet, and the judge has to make a ruling, and that's probably what seems to have happened today before they started the proceedings, even though the press was allowed in there. And spectators were allowed in there, but the judge made a ruling that anyone who says about what went on there is probably going to be held in contempt of court. So no one's saying what went on there, at least not till Monday, because of the rule to sequester. Now they get on to Becky Hill's examination. And apparently the court said that the court plans, the judge, Justice Toll, plans on asking the questions to Ms. Hill herself. That's what the implication from this response is. And this is what Mr. Murdaugh's response to that is. Mr. Murdaugh objects to the court examining Ms. Hill at all, meaning, no, this should be an attorney right. Mr. Murdaugh should have a right to confront Becky Hill. And then they make a number of different arguments about why they should be able to confront Ms. Hill. A whole bunch of different arguments. You know, she's a public official, and she submitted an affidavit saying that she did no wrong, and therefore she's putting her credibility on the line. And then they start arguing about which type of, how they can be able to impeach Ms. Hill through different means. So that's essentially the rest of this filing. But I just want to make one point, and then I'll just tell you what the Murdoch's team's questions, what they want the questions to be. The last point I want to make is that according to this justice herself, according to Justice Toll, in her opinion, really, there should be a very big possibility that Becky Hill not be questioned at all. Because according to the judge, you have to prove that the jury was prejudiced. That burden is on the Murdoch team. And if all the jurors get up there and say that, yes, there was communications between Ms. Hill and the jury, and she said things like, watch him, and she said things like, don't be fooled by him, and let's say they say all the stuff that the Murdoch team's alleging Becky Hill said. But at the end of the day, if the jurors say, it didn't affect my verdict, it just didn't affect my verdict. I didn't like it, and I didn't appreciate it, and I thought it was inappropriate, but I still based my verdict on the evidence presented in court. If that's what they answer, then I don't understand, according to this judge, why Ms. Hill would even be questioned at all. Because they haven't, the Murdoch team cannot satisfy their burden now. The jurors have all testified. Now, I'm saying if they testify like this, then they at that point will have testified that there was no prejudice. And it's not presumed, according to this judge. So therefore, there's no reason at all to call Ms. Hill. So I'm not sure why even Ms. Hill would even be called if the jurors all say that it did not affect, that it did not prejudice their verdict. And on the other hand, if it did prejudice their verdict, if they're saying that it did prejudice their verdict, then again, why would you need to call Ms. Hill? As long as the jurors are saying that it prejudiced their verdict and it changed the way that they thought about the case, and that's why they based their verdict on some of the statements that Ms. Hill said, so who cares about calling Ms. Hill on the stand? As long as the jury says that their verdict was affected, so then what's the point of getting Ms. Hill on the stand? So I'm not 100% sure why Ms. Hill has to testify at all in this situation. So that is my take on some of this stuff, and I just want to read for you what the Murdoch's team, what their proposed questions are. Question number 1. Did you hear Ms. Hill make any comments about the testimony, evidence, or arguments presented by the state or defense, or the anticipated length of your deliberations during Ms. Murdoch's trial? So did you hear any comments from Ms. Hill about that? If the answer is no, no further questions. If the answer is yes, then ask the following questions. Number 1, what comments did you hear Ms. Hill make? Next question, who else was present when Ms. Hill made those comments? Next, did Ms. Hill comments influence you in any way, and if so, how? And last question, did Ms. Hill comments prejudice you against defendant Alex Murdaugh in any way, however slight? So if it prejudiced you in any way against Alex Murdaugh, so then, however slight, if you answer yes to that, then that's the end of that. So that's their questions that they proposed. We don't know, again, exactly, clearly what the court eventually agreed to ask. I went through to see what the proposed questions were and what some of the arguments to be made against some of those arguments are. And again, like I said from my last video, I really believe the law to be, from my understanding, under State versus Green, that really they should not have to prove prejudice. It should really just be presumed under, like followed in Remmer versus the United States. But we will see what happens on Monday. So stay tuned. I'm sure we'll break it down for you afterwards. And that will be it for today. If you haven't yet, please like, subscribe, and we will see you next time.